In the previous videos, we talked about clause 27, which is the nominated subcontractor. We mentioned that the expenditure related to the nominated subcontractor, it shall be under the prime cost sum or the provisional sum. We also established the functions of the nominated subcontractor, as well as the obligations of this nominated subcontractor. We know that the nominated subcontractors are the person nominated by the architect or the employer, which will be under the responsibility of the contractor, as the nominated subcontractor is actually subcontracting contract from the contractor. The contractor has the right to object the nominations of the subcontractor, but will require reasonable reasons. If the objections is reasonable, the architect can choose to renominate another subcontractor or remain with the original subcontractor or omit the relevant works from the contractor while remaining the original subcontractor. We also mentioned about the relationship between the nominated subcontractor, contractors and the employer. There is no direct relationship between the employer and the nominated subcontractor. The relationship it will be between the employer and the contractor. And then another relationship it will be between the contractors and the nominated subcontractor. This relationship will govern the payment later. The nominated subcontractor will need to deliver the work to the contractor, and the respective work will be integrated together with the work of the contractor to be entirely delivered to the employer. In terms of the payment, the employer pay to the contractor. The contractor acquire his portions of the profit and pay the nominated subcontractors for the portions for the nominated subcontractor. The architect has the right to request and check whether the contractor has actually paid the nominated subcontractor, whether the nominated subcontractor is being exploited by the contractor. If the relevant payment has already been made, the contractor will need to provide evidence. If the payment has not been made due to some valid reason, the contractor will need to justify the reason of withholding the payment. Now, if the payment is unreasonably being withheld, the architect and the employer can choose to interfere, or they can choose not to interfere. They are not obliged to do so. Whichever conflict between the nominated subcontractor with the contractor, they will need to resolve by themselves for dispute resolutions. In these videos, we're going to extend our discussions related to the determinations of the nominated subcontractor's employment. That means we are talking about the circumstances the service of the nominated subcontractor can be terminated. PAM contract allows the contractors to determine the employments of the nominated subcontractor. That means the contractor can terminate the nominated subcontractor, but this will require the written consent of the architect, since the nominated subcontractor is nominated by the architect. The contractor will require the consent from the architect. In order to get the consent, the contractor will need to send a written report to the architect, justify and stating the default of the nominated subcontractor. This report will need to provide a copy to the nominated subcontractor so that the nominated subcontractor is aware of the case. This process needs to be done in transparency to the nominated subcontractor as well. Then the architect may request the nominated subcontractor to respond to the report before deciding. This provides chance for the nominated subcontractor to clarify and explain himself. This is in case any accusations by the contractors is inaccurate, hoping this could resolve the conflict between the two parties. This is to be made fair to the nominated subcontractor, that the architect will need to acquire the clarifications from both sides before deciding whether to determine the employment of the nominated subcontractor. Next, we talk about the contractor's responsibility for the nominated subcontractor. It says here the contractor is fully responsible of the nominated subcontractor in carrying out the subcontract work. The quality and standards should reach to a reasonable satisfaction of the architect. We have established previously the relationship. It will be between the employer and the contractor, and the contractor with the nominated subcontractor. With that, the contractor is fully responsible for the nominated subcontractor. He will need to ensure that the nominated subcontractor carry out the work in accordance to the requirement, so that he himself can deliver the work after integrating the part by the nominated subcontractor to a satisfactory level to the architect. In the case that the nominated subcontractor does not deliver the work as per the standard, the nominated subcontractor is liable to the contractor. And because of the nominated subcontractor part is not up to the standard, when delivered to the employer, the contractor will be liable to the employer. Then when come to the indemnify the losses, the nominated subcontractor is to indemnify the contractor, while the contractor is to indemnify the employer. If the non-conformance is fully due to the nominated subcontractor, the loss bear by the contractor can be fully transferred to the nominated subcontractor. This leads to a situation that the contractor is the middle person. Ultimately, the nominated subcontractor will have to bear with the losses suffered by the employer. Next is about employer no privity of contract with nominated subcontractor. That means the employer has no legal relationship with the nominated subcontractor. We have been mentioning about this quite a number of times.